Nicolas Maduro and Cilia Flores attorneys just dropped a judicial bombshell in the Southern District of New York that nobody expected at this stage of the proceedings. In very simple terms, the message they sent to the court is absolutely demolishing. Either you let us collect our fees, or we abandon them to their fate. That blunt, that direct. No diplomatic softening, no legal euphemisms. The most wanted couple in American justice could find themselves without private legal defense within days. And this, dear friends, changes absolutely everything on the board of this historic narco-terrorism trial that has millions of Venezuelans on edge. But wait, because what comes next is even more revealing, and it carries implications that few are analyzing with the depth they deserve. The legal trap they themselves have constructed with this motion could force them to confess exactly where they have hidden their multi-million-dollar fortunes. Stay until the end because this is getting genuinely fascinating and there is crucial information you cannot miss. Today is Friday, March 20th, 2026. Welcome to Punto de Quiebra al Minuto. I am Laura Salazar, and we have an absolutely loaded day of crucial information for Venezuela and for everyone who has been following this process closely. Let us get straight to the point, because there is too much to analyze and every detail counts in this story that writes itself day by day. The motion that attorneys Barry Pollack and Mark Donnell filed before the federal judge lays out three very clear alternatives, and each one deserves detailed analysis. First option, dismiss all charges against their clients entirely, alleging a supposed violation of constitutional due process. Second option, allow them to access Venezuelan state funds to pay their astronomical professional fees amounting to millions of dollars. Third option, formally authorize their withdrawal from the defense, leaving Maduro and Cilia to manage with public defenders assigned by the court. But here is what nobody is explaining to you clearly, and it is absolutely fundamental that you understand this. Let us analyze what each scenario actually means, because there is an enormous amount to unpack, and the implications are enormous for the future of this process. The first option is practically impossible from any reasonable legal standpoint. No federal judge in their right mind is going to throw years of meticulous investigation into the garbage simply because some extremely expensive attorneys cannot collect their fees. That would set an absurd precedent, allowing any wealthy defendant to escape justice by claiming payment problems with their legal representatives. The second option clashes directly and head-on with the sanctions imposed by OFAC, the Office of Foreign Assets Control within the Treasury Department that manages assets linked to individuals sanctioned by the American government. Venezuela as a state is under severe sanctions, and Venezuelan public funds cannot flow freely into American accounts to pay for private services. This is not bureaucratic caprice. It is a state policy that has been implemented rigorously for years. And the third option? Well, that is precisely the one that has Maduro and Cilia genuinely trembling in their respective cells, because they know exactly what it means. Imagine for a moment the complete scenario they would face. Two people accused of extremely serious narco-terrorism crimes, potentially facing life sentences, ending up represented by attorneys assigned for free by the American state. Lawyers they did not choose under any circumstance, who they probably do not know personally, who simultaneously handled dozens of complex cases with limited resources. The perfect legal nightmare for someone who for decades was accustomed to buying absolutely everything with other people's money, with the resources of an entire nation at their disposal. Do you honestly believe Maduro and Cilia will end up with court-appointed public defenders after having managed the wealth of Venezuela? Leave me your opinion in the comments because I want to read what you think about this. The American public defense system deserves a detailed explanation to understand what they would be facing. Federal law is very serious about due process and the fundamental right to defense of any defendant. There is a selected group of attorneys who have passed through rigorous review processes by the court and who are authorized to represent individuals prosecuted for federal crimes. These public defenders are legally obligated to provide adequate representation in accordance with applicable rules. They must file all corresponding motions, prepare solid arguments, do their jobs professionally. However, there is abundant case law about processed individuals who ended up deeply dissatisfied with their assigned defenders for various reasons. Many complain about inadequate communication, lack of personal empathy, and inability to feel sufficient trust in whoever represents them. And here comes the complication. The grounds for requesting a change of public defender must be extremely serious and fully justified. Simply saying you do not like your attorney or do not fully trust their professional judgment is not sufficient. In other words, Maduro and Cilia could end up represented by someone who generates zero confidence in them, and they could do absolutely nothing about it. Furthermore, these public defenders would likely not provide the complementary services that expensive private firms habitually offer: media management of the case, calculated influence on public opinion, communication strategies running parallel to the judicial process. In cases where a jury of ordinary citizens is eventually constituted, public perception plays a tremendously important role in the final outcome. A public defender will not necessarily invest resources in shaping that perception favorably toward their clients, as a multi-million-dollar private firm would. Now comes the truly explosive part of this story, and this is what nobody else is telling you with sufficient clarity. OFAC, in its formal response to this attorney request, left a door apparently open that in reality functions as a perfectly designed lethal trap. They communicated with complete clarity. You cannot use Venezuelan state funds under any circumstances, but you can access your personal funds if you have any available. At first glance, this seems like a reasonable and even generous concession from the American authorities. But let us analyze the real implications of this alternative. To access those supposed personal funds they hypothetically possess, Maduro and Cilia would have to formally declare before the court exactly what those resources are. They would have to specify in detail bank account numbers and locations, real estate properties in any country, financial investments of all types, tangible and intangible assets. Essentially, they would have to completely open the books of their true net worth before American justice. And if they stubbornly resist declaring the existence of personal funds, the judge has the legal authority to demand a complete sworn patrimonial declaration from them. Do you understand the extraordinary magnitude of what this means for them? They would be legally obligated to reveal their true wealth under solemn oath before a federal court. Lying in that declaration constitutes an additional federal crime with devastating consequences. Telling the truth would expose colossal fortunes that officially do not exist under their names. The resulting dilemma is absolutely delicious from the perspective of those of us who have sought justice to finally reach these individuals. If they declare they have nothing, the judge can investigate and contrast that claim against the information held by agencies like OFAC itself. If they declare they do have resources, they would be admitting a net worth they officially should not possess, given their declared government salaries over decades. The question is inevitable. Where did that money come from if they were officially living on government wages? The circle closes with implacable logic. Now let us be absolutely realistic about the patrimonial situation of this pair. We all know perfectly well that Maduro and Cilia very probably have monumental fortunes carefully hidden under the names of frontmen, distant relatives, shell companies, and opaque corporations in tax havens. It is the classic manual used by every kleptocrat throughout history. Having nothing registered under your own name while silently controlling millions or even billions in the shadows. They may be confident that a surface review will find no properties or accounts directly linked to their personal names. But here is an important detail that enormously complicates things for them in this specific context. Switzerland recently imposed new specific and direct sanctions against Maduro, expressly linked to assets under Swiss jurisdiction. The Swiss have a worldwide reputation for being extremely cautious and methodical. The Swiss government does not sanction for sport or under superficial political pressure. If they took that formal decision, it is because they possess concrete and verifiable information about specific assets they can effectively freeze. This strongly suggests that traceable assets linked to Maduro exist within the international financial system, however hidden under layers of intermediary corporations. American OFAC also manages privileged and extremely detailed financial intelligence on every person it has sanctioned over the years. They have been systematically tracking the financial movements of the Chavista leadership for more than a complete decade. They know patterns, detect anomalies, identify connections that are not evident to outside observers. They know far more than they publicly appear to know. Do you believe financial intelligence agencies do not have the hidden fortunes of these individuals fully mapped out? Comment what you think about their real capacity. If Maduro solemnly declares under oath that he does not possess a single cent, while the agencies hold documentary evidence to the contrary, his judicial problem multiplies exponentially. He would be adding perjury to the already extensive list of charges he faces, which would significantly aggravate his procedural situation. Let us now talk in detail about the delay strategy, because this is also absolutely fundamental to understanding the complete game they are attempting to execute. The attorneys are formally requesting a special hearing dedicated exclusively to discussing this specific point about fee payment. That request could potentially postpone or reschedule the hearing that was set for March 26th, where the accumulated evidence was going to be comprehensively reviewed. Why does it suit them strategically to delay the process as long as possible? Because what they really want to avoid at all costs is reaching the evidentiary disclosure phase where the prosecution must show its cards. The American government holds an impressive body of evidence accumulated patiently over approximately 15 years of continuous and uninterrupted investigation. This particular case did not emerge from nowhere or get constructed hastily. It derives directly from prior files against figures like Limcy Salazar, Hugo Carvajal, and other close regime collaborators who at their moment decided to cooperate with American justice. Many of them have provided devastating testimony, compromising documents, and connections that previously remained hidden. 15 complete years of meticulous investigation mean recorded testimony from protected witnesses, classified reports from multiple intelligence agencies, court-authorized communications intercepts, and financial documents obtained through international cooperation. All of that explosive material is patiently waiting to be formally disclosed to the defense, and once that happens, the panorama for Maduro and Cilia will become infinitely darker and more complicated. Pay close attention to this detail because it reveals the absolute desperation underlying this apparently technical legal strategy. The attorneys insist in their motion that under current Venezuelan law, the state is legally obligated to cover Maduro and Cilia's defense costs in foreign courts. They categorically affirm that an established legal right exists for Venezuela to pay these astronomical private representation expenses. But there is a truly enormous problem with this argument they are attempting to sustain before the federal judge. When any serious jurist exhaustively reviews current Venezuelan legislation, they find absolutely no rule establishing such a specific obligation. The law of the Attorney General's office does effectively obligate representation of the Republic as a legal entity and protection of its patrimonial interests. Venezuelan administrative law does establish legal representation mechanisms for various state entities in their official actions. But no currently valid Venezuelan law obligates the state to pay private foreign attorneys for individual citizens being criminally prosecuted in foreign jurisdictions for supposed personal crimes. This specific trial does not involve PDVSA corporate assets, Venezuelan public debt controversies, or state commercial disputes. They are strictly individual criminal charges for responsibilities that the prosecution qualifies as personal and non-transferable. In the eyes of the American federal court, Maduro and Cilia are simply two natural persons like any other defendant who appears before justice. The prosecution already stated it forcefully in the opposition it filed on March 13th. They know of absolutely no historical precedent where a sovereign government has paid the private defense of individual citizens processed in foreign criminal courts. And do you know what specifically the attorneys base this supposedly non-existent right upon? Exclusively on sworn declarations signed by Maduro and Cilia themselves from their cells. They personally affirm under solemn oath that Venezuelan law grants them that right. But curiously, they cite no specific article and no concrete law to support that categorical claim. It is exactly like claiming you have an indisputable right to something simply because you repeatedly assert it yourself, without ever showing where that supposed right is actually written. If the judge decides to dig seriously into this particular point, he could perfectly discover that the first formal lie of this trial has already been pronounced and documented. Asserting something under oath that lacks verifiable legal basis is extremely dangerous before an American federal court. The consequences can be devastating. Regarding the recurring question about whether Maduro is supposedly Colombian by birth, which has been circulating intensely on social media, we must be absolutely clear and precise. As of March 19, 2026, the complete judicial file contains no official mention of Maduro's national origin. The federal prosecution has presented no procedural action on this specific point. No formal hearing has addressed it. However, the fundamental issue of legitimacy has already been completely settled through another, far more direct and decisive legal channel. The United States officially does not recognize Maduro as Venezuela's legitimate leader since January 23, 2019. Trump established that formally through official action during his first administration, and that governmental decision remains fully in force today. Last week, the State Department publicly ratified this position through an official document called a Statement of Interest, already being cited in multiple judicial proceedings related to Venezuela. For the practical purposes of any future argument about diplomatic or head of state immunity, this is absolutely determinative. They do not need to laboriously prove Maduro was born in Colombia to deny him any form of immunity. They simply do not recognize him as Venezuela's legitimate authority. Case completely closed on that procedural front. Now let us change the subject, because there is another piece of news with truly chilling implications. And when I say chilling, I choose that word with complete, deliberate intention. In Spain, the complex Aldama case has taken an absolutely macabre turn that genuinely raises the hairs on any attentive observer's arms. Victor de Aldama is the businessman who personally received Delcy Rodriguez when she arrived clandestinely at the Madrid airport during that secret visit discovered by journalists. This figure has been cooperating with Spanish justice and recently handed the investigating judge an envelope with supposed documentary evidence of illegal financing of the Spanish Socialist Party from Venezuela. In that delivered material, Aldama specifically identified a businessman named Francisco Flores as the operational nexus between money originating from PDVSA and various actors in Spanish politics. Journalistic investigations accompanying this case also linked him to activities related to international drug trafficking. A shadowy figure, but apparently key to understanding how Venezuelan resources flowed into Europe. And here comes the truly chilling part that has all of Spain in a state of absolute shock. Francisco Flores, just 55 years old, appeared dead. But he did not die yesterday or last week or even this month. He passed away on February 6th, and absolutely nobody outside his intimate circle knew publicly. His death only became known now, precisely when his name began circulating intensely in Spanish media as a potentially key piece of this international corruption investigation. Not even Aldama himself, who mentioned him before the judge as a fundamental witness, knew that Francisco Flores was already dead when he made that declaration, 55 years old. Definitively not a typical age to die so suddenly without it becoming publicly known in some form. He was a businessman with some public visibility. He had a foundation established in his name. he maintained verifiable public activity. How is it humanly possible that his passing remained completely hidden for more than a full month? Francisco Flores can now never testify before any court. He can never deliver documentary or testimonial evidence about what he knew. He can never be summoned or questioned by any investigating judge. Conveniently for many, he took everything he knew to the grave, precisely when his name was beginning to gain public relevance. And this, unfortunately, adds to a disturbing pattern that is absolutely impossible to ignore for any objective observer. Piedad Córdoba, the controversial Colombian senator who was historically the first public figure to openly affirm that former President Zapatero had direct economic interests in Venezuela, also died suddenly at 69. Juan Carlos Marquez, a key witness identified in the Minuto case, which investigated the lucrative commissions supposedly collected by Zapatero's ambassador in Caracas, formally announced to the authorities that he was prepared to fully cooperate with Spanish justice. The day after making that announcement, he appeared dead, officially suicide. 3 deaths, 3 people directly linked to the same corruption network between Venezuela and Spain. 3 potential witnesses who can now never speak or provide evidence. Coincidences, when they accumulate in this strikingly convenient manner, simply stop appearing as coincidences to any rational mind. The pattern is too evident, too convenient for certain powerful interests that prefer specific truths never fully emerge into public light. Aldama, for his part, recently declared that he seriously fears for his own life after unknown individuals shot up his personal vehicle in an attack that could have been fatal. Viewing this complete panorama with all its edges, he frankly has more than sufficient reason to be genuinely worried about his safety. What do you think about these so timely and convenient deaths? Statistical coincidence or something far more sinister operating in the shadows? I need to read your theories and reflections in the comments. Let us now move to other important news from Venezuela itself. Yesterday, nearly a dozen new ministers were formally sworn in at the Miraflores Palace, and there are genuinely striking elements in these appointments that deserve careful analysis. For the first time in a long while, the regime incorporated figures who ostensibly do not belong to the official government party. They appointed a recognized professor from the Central University of Venezuela as Minister of University Education. They designated a deputy who identifies himself as opposition as Vice Minister of the same portfolio. This is clearly the facade of plurality and openness they are desperately trying to sell to the international community. Jorge Rodriguez celebrated these appointments in the National Assembly with notably theatrical and exaggerated enthusiasm. But observe this revealing detail. The applause coming from the ruling party benches was noticeably tepid, almost forced, lacking any genuine enthusiasm. Can you imagine the profound internal discontent that must exist among career Chavista cadres? They have spent years patiently waiting for their turn to access important positions with their corresponding benefits. And now they watch helplessly as ministerial positions are handed to supposed opponents while they remain indefinitely on a waiting list. The internal tension must be considerable, even if not openly expressed out of fear of reprisals. A curious detail from the solemn swearing-in ceremony caught the attention of many attentive observers. There were no portraits or images of Chavez or Maduro visible in the room chosen for the ceremony. They deliberately searched for a space inside Miraflores stripped of that revolutionary iconography, which now turns out to be particularly inconvenient for the new moderate image they are trying to project internationally. Delcy Rodriguez executed the oath with a rather strange hand gesture that numerous people noticed and immediately commented on across social media. Some observers noted similarities with the international signal that people in situations of danger, kidnapping, or coercion make to silently alert others. We will need to carefully analyze what that unusual body language might mean in such a formal context. Speaking precisely of Delcy, this woman practically lives receiving Laura Dogue in the halls of Miraflores as if they were old friends. The American chargé d'affaires visited the presidential palace again this week, accompanied by an official delegation from the Senate Foreign Relations Committee. Curiously, the specific names of the participating senators were not revealed in the official channel's propaganda coverage. Do not worry, we will find out who was on that delegation. What is truly striking is observing how Laura Dogue enters the Miraflores facilities whenever the camera captures her. She does not walk with the characteristic timidity of a diplomatic guest in foreign territory. She enters with the assured confidence of someone who knows every hallway, every room, every corner of the place perfectly. She almost seems like the natural host of the palace rather than simply a foreign visitor passing through. This observable dynamic reveals quite clearly who actually holds effective control of the current situation in Venezuela. Negotiations between Washington and Caracas are advancing at a dizzying pace that very few analysts correctly anticipated. Back on January 3rd, practically nobody imagined that the Trump administration and Delcy Circle would reach such fluid understanding in so little time. Do you believe Laura Dogue currently holds more real power in Venezuela than many ministers of the regime itself? Comment your perspective on this peculiar dynamic. While these meetings occur in Caracas, Maria Corina Machado had a critically important meeting in Washington with influential Republican Senator Rick Scott. Let us recall that there was previously an uncomfortable misunderstanding related to an invitation to the Presidential State of the Union address. However, this bilateral meeting appears to have satisfactorily redirected that strategic relationship back toward productive channels. Scott published on his social media immediately after the encounter that he will not stop his efforts until every single Venezuelan political prisoner is freed and a clear path toward genuinely free and fair elections exists in Venezuela. He is undoubtedly a valuable ally for the democratic cause. He was a successful governor of Florida for 2 terms. He carries enormous political weight within the National Republican Party, and his former chief of staff currently occupies the number 2 position in Trump's White House. Maria Corina undoubtedly faces an absolutely crucial moment of strategic reflection in her political trajectory. The scenario she found upon arriving in Washington differs substantially from what she probably anticipated. Trump appears to be negotiating directly with Delcy in ways that nobody foresaw just a few months ago. What that means for the immediate political future of Venezuela is a question that every Venezuelan who truly cares about the democratic destination of this country must be asking themselves right now. What we can affirm with certainty is that the judicial process against Maduro and Cilia advances with the inexorable force of a system that does not slow down for anybody. The attorneys can file all the motions they wish. They can request all the special hearings they desire. But the evidence accumulated over 15 years does not disappear. The witnesses who already testified do not retract. The intercepted communications do not erase themselves. The financial trails do not vanish. Every legal maneuver they execute is one more step toward the inevitable. Whether they end up with private attorneys, public defenders, or no attorneys at all, the destination remains the same. Justice has been patient. Justice has been methodical. Justice has been building this case brick by brick for a decade and a half, and justice does not back down because someone forgot to pay the bill. I am Laura Salazar, and this has been Punto de Quiebra al Minuto. Stay informed, stay united, and above all, stay certain that the truth always finds its way to the surface, no matter how many layers of lies attempt to bury it. We will see you in the next installment with more information, more analysis, and the same unwavering commitment to telling you what is really happening. Take care of yourselves.